The term tenant screening reports refers to any report that will have history of a tenant's activities or court cases in housing court. So if you've been brought to housing court, that may appear on a tenant screening report.
A lot of cases are brought where there's absolutely no fault involved on the part of the tenant. But these reports don't distinguish between tenants who legitimately had reasons to either withhold their rent, or the landlord may have sued them by mistake, or the landlord may have sued them as part of a scheme to get a rent-regulated tenant out of their apartment. So there are all kinds of reasons why somebody can be sued in a housing court case that have nothing to do with their, how good a tenant they would be.
The court, the Office of Court Administration, which has this database as part of their court records, processes that data, packages it, and actually resells it to several companies who have contracts with them. Those companies then bundle that data and then either directly resell it to landlords or will resell it to other companies who then resell it.
There's some confusion about the difference between credit reports and tenant screening reports. Credit reports really reflect a person's entire credit history, including credit card debts, student loan debts, medical debts. It also includes information on court judgments, including housing court judgments. Tenant screening reports are narrower. They include information on a person's housing court history. They also include other things like criminal history and some parts of a person's credit report. And a lot of the same concerns exist for both. Both of them really have a disproportionate impact on people of color. And there's also a lot of concern about inaccuracies in both credit reports and tenant screening reports.
Over the past 10 years, if you go along the L line, for example, little by little you start seeing more young people moving in, and that is directly affecting long-term residents with displacement, because the rents originally here were quite affordable, and as new people are moving in, owners want to get more money for their apartments, and they start finding ways to harass, displace tenants. And every day we are losing more apartments, more affordable housing apartments. The icing in the cake pretty much happened about 5 years ago when the area that we had mostly industrial warehouses and factories, mostly around the waterfront by the East River, the city decided to rezone it. So pretty much change it from industrial use to residential. But that's also prime real estate because it's facing the skyline of Manhattan. So the rezoning happened, and mainly just luxury housing was built around the waterfront. As a response, the community we organized, and one thing that we expected is to have a certain percentage of affordable housing units to be built. The total number came to about 33%, they said, but so far we haven't seen not even maybe 15% of that affordable housing to be built.
Tenants in New York City have a lot of rights, and they're brought to housing court for all kinds of reasons, some of which are not their fault, and some of which are just them exerting their rights. With the recent foreclosure crisis, we've had a lot of tenants that are brought to courts by the banks that ended up repossessing the house. So in a foreclosure case, in a 2 or 3 family home, the bank will come in and begin foreclosing proceedings, and then they'll own the house. Banks don't like tenants, so they then move to evict everybody in the household, even the tenants. And these can be tenants who are excellent tenants who've paid their rent every month, but just because the bank doesn't want them, they'll bring them to housing court to have them evicted. Those tenants now have a housing court case on their record, and when they go to try to relocate, they'll have a very hard time finding housing because of this so-called negative history. The other problem we see is that in New York City, you have a right to withhold your rent for repairs. And if you have a negligent landlord, this was always one of the most powerful ways to get repairs done. Rent strikes were a very common way that a group of tenants would get together to get necessary repairs.
one of the cases that I know is this couple, couple in their 30s that they were a few years ago, maybe like 7 years ago, were living in this building in complete abandonment. The landlord was completely absent. The only time that he showed up was to collect rent pretty much every month. After we organized in the tenant association, trying to mediate with the landlord, and we tried to reach him, he never responds. So the tenant decided to start a rent strike. The landlord decided to take these tenants to court for a non-payment procedure. When we went to court, the actual judge included in the stipulation that the landlord needed to do all these repairs in order to get the money. So there wasn't a judgment against the tenants, there was a stipulation. 2 years ago, this couple came to us because they wanted to apply for one of these waterfront apartments. They qualified income-wise. They had a pretty decent credit. So, they had a very good chance of meeting the requirements. The big surprise was when they got their screen report and their credit report is that they had a non-payment in the record. That non-payment from 7 years ago, and they got rejected.
Recently, the New York City Council did pass something called the Tenant Fair Chance Act. And under this law, a prospective landlord is required to tell you if they use a tenant screening company, and if they do use that tenant screening company, the name of that company. So that gives tenants the opportunity to see which company, to try to get a copy of their report. If there's any errors or any problems, they can go in and try to get that cleaned up and then make the application. The other thing tenants can do is they have a right under New York and federal law to have explanations put on the report. So they could have something that says, yes, I was brought to court in 97 or 2011, but it was because the building was foreclosed upon. And then that is supposed to appear on the tenant screening report.
A real fundamental problem here is the courts continuing to sell this data, these housing court records to private tenant screening companies. These records, first of all, these records are really rife with inaccuracies, incomplete information that is really prejudicial to many people. But also, the court's stated mission is to promote the rule of law and to serve the public. And in fact, selling this data in bulk to tenant screening companies does just the opposite. It penalizes people who have used the courts to exercise their rights, and it discourages people from doing so in the future. It's fundamentally unfair.
We do not believe, and I say we mean tenant advocates don't believe that housing court records should be sealed. They're absolutely open. Anybody can go down to the courthouse and ask to see a file. That's, we have an open court system, and we're certainly not suggesting that it shouldn't remain open. But what the court system is doing is providing, we believe, inaccurate and misleading data to these companies who are happy to pay for it.
People should also, if they're affected by this or concerned by the fact that the court is selling data and at a harm to the people of the state of New York, should contact their local elected officials to get them involved in this issue.